All rise.
Please be seated. Good morning, everybody. Registrar, would you please call the case?
The Appeals Chamber of the International Criminal Tribunal for Rwanda, composed of Judge Theodore Meron presiding, Judge Fausto Pokar, Judge Arlet Ramarosan, Judge Bakhtiar Tuzmukhamedov, and Judge Kofi Kumelio Afande, is now sitting in open session today, Monday, 29 September 2014, for the delivery of the appeals judgment in the case of Edward Karamera and Mathieu Ngirampatse versus the prosecutor, case number ICTR-98-44-A.
Thank you. Mr. Karamera, can you hear the proceedings in a language you understand?
Oui, Monsieur le Président.
Yes, Mr. President. Thank you.
Mr. Ngirampatse, can you follow the proceedings in a language you understand?
Oui, Monsieur le Président.
Yes, Mr. President, I can hear the interpretation into French.
Appearances of the parties. First, counsel for Mr. Karamera.
Bonjour.
Good morning, Mr. President. Good morning, Your Honors. My name is Diodian of the Senegal Bar Association, and I'm present here to defend the interests of Mr. Edouard Karamera. I have by me the President of the Bar Council, Felix So, as well as Mr. Bernard Munyadreza, who is our legal assistant. I thank you.
Thank you. Counsel for Mr. Ngirampatse, please.
Je vous remercie, Monsieur.
Thank you, Mr. President. Mr. President, Your Honors, I would like to convey to you my regards on behalf of Mr. Ngirampatse. I am Frederic Veil of the Paris Bar Association, and besides me, I have my assistant, Mr. Jean-Paul Simbizi, and Jean Chrysostome Ntiru Libambe. I thank you, Mr. President.
Counsel for the prosecutor.
Good morning, Mr. President, and Your Honors, and welcome back to Arusha. With me, the prosecutor, Deborah Wilson, Chief of Appeals, Abubakar Tambatu Takesenze, Appeals Counsel, William Mubiru, Sunkalipala Conte, and Marika, Assistant Appeals Counsel, as it pleases the court.
Thank you, Prosecutor General. Good morning, everybody. As the registrar announced, the Appeals Chamber is sitting today in accordance with Rule 118 of the Tribunal's Rules of Procedure and Evidence in the case of Edward Karamera and Mathieu Ngirampatse against the prosecutor. Karamera, Ngirampatse, and the prosecutor have appealed against the trial judgment rendered in this case by Trial Chamber 3 of the Tribunal on 21 December 2011 and issued in writing on 2 February 2012. Following the practice of the tribunal, I will summarize the findings of the appeals chamber. Not every point addressed in the judgment will be mentioned in the summary, which focuses only on central issues. The summary does not constitute any part of the authoritative written judgment of the appeals chamber, which will be distributed at the close of the session. I will now turn to the appeal of Caramera and Nzabonimana. During the relevant events, Caramera was a high-ranking member of the MRND party. On 25 May 1994, he became Minister of the Interior and Communal Development for the interim government. In 1994, Nzabonimana was the National Party chairman of the MRND party and chairman of its executive bureau. The trial chamber convicted Caramera and Nzabonimana pursuant to Article 6(1) of the statute of direct and public incitement to commit genocide, rape and extermination as crimes against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions, and Additional Protocol 2 thereto. Additionally, the trial chamber convicted Caramera, pursuant to Article 6(3) of the statute, for genocide, extermination as a crime against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions, and Additional Protocol 2 thereto. In addition, the trial chamber found Caramera and Nzabonimana guilty of conspiracy to commit genocide by at least 25 May 1994, but did not enter a conviction for this crime on the basis of the principles relating to cumulative convictions. The trial chamber sentenced Caramera and Nzabonimana to life imprisonment. A. Fairness of the proceedings. Caramera and Nzabonimana submit that their fair trial rights were violated. The appeals chamber finds that Caramera and Nzabonimana failed to demonstrate that 1. The trial chamber's conduct of the proceedings shows bias against Nzabonimana. 2. The trial chamber's approach to the collection, presentation and assessment of evidence shows bias. 3. Nzabonimana's right to equality before the law was violated. 4. Nzabonimana's right to trial without undue delay was violated. 5. The trial chamber erred in rejecting Nzabonimana's argument that a conflict of interest arose from the prosecution's employment of his former legal assistant, and 6. The trial chamber failed to remedy any prejudice caused to Caramera by the prosecution's disclosure violation. The appeals chamber did find that Nzabonimana's right to be promptly informed of the reasons for his arrest was violated. However, it concludes that the trial chamber provided an adequate remedy in refusing to admit into evidence the statement that Nzabonimana provided to the tribunal investigators. B. Notice. Caramera and Nzabonimana also challenge the trial chamber's assessment of the notice they received in relation to 1. Pre-8 April 1994 allegations and certain terminology used in the trial judgment. 2. The pleading of joint criminal enterprise. 3. Their superior responsibility. And 4. The cumulative effect of the curing of the defects in the indictment. The appeals chamber is not convinced that Caramera and Nzabonimana have identified any error in the trial chamber's assessment of the sufficiency of the notice that was provided to them. C. Joint criminal enterprise. The trial chamber found that Karamera and Nigirampatse participated in a joint criminal enterprise to destroy the Tutsi population in Rwanda through the commission of the crimes charged in the indictment. Karamera contends that the trial chamber erroneously inferred from the evidence that a joint criminal enterprise existed. Nigirampatse submits that the trial chamber erred in holding him responsible as a participant in a joint criminal enterprise. The appeals chamber finds that Karamera and Nigirampatse have not demonstrated that the trial chamber erred in holding them responsible based on the basic form of joint criminal enterprise for crimes committed after 18 April 1994. D. Superior responsibility. I will now turn to Karamera's and Nigirampatse's challenges regarding the trial chamber's findings in relation to their superior responsibility under Article 6.3 of the statute. With respect to the trial chamber's finding of Karamera's and Nigirampatse's responsibility as superiors for the participation of the Kigali Interrahme in the killings of Tutsis in Gitarama, which followed a meeting at the Murambi Training School on 18 April 1994, the appeals chamber finds that the trial chamber erred in failing to explain its finding. With respect to the rapes committed outside Kigali throughout Rwanda, the appeals chamber finds that the trial chamber failed to specifically identify the perpetrators as Karamera's and Nigirampatse's subordinates. Accordingly, the appeals chamber reverses the trial chamber's findings that Karamera and Nigirampatse bear superior responsibility pursuant to Article 6.3 of the statute over the Kigali Interrahme in relation to the killings committed in Gitarama Prefecture following the Murambi Training School meeting on 18 April 1994 and over the Kigali and Gisene Interrahme in relation to the rapes and sexual assaults of Tutsi women committed outside Kigali from April to June 1994. However, given that Karamera's and Nigirampatse's responsibility as superiors for these crimes was only taken into account as an aggravating factor in sentencing, as they were already found guilty for these killings under the basic form of joint criminal enterprise, and for these rapes and sexual assaults under the extended form of joint criminal enterprise, their convictions for these killings under the basic form of joint criminal enterprise and for these rapes and sexual assaults under the extended form of joint criminal enterprise remain untouched. The appeals chamber dismisses Karamera's and Nigirampatse's arguments in all other respects. E. Pre-8 April 1994 meetings. Nigirampatse submits that the trial chamber erred in assessing the evidence related to pre-8 April 1994 rallies, as well as the meaning of Hutu power prior to 8 April 1994. For the reasons set out in the trial judgment, this argument is dismissed. F. Distribution of weapons and killings in Kigali on 11 and 12 April 1994. The trial chamber found that on 11 April 1994, weapons were distributed to the Interrahme in the presence of Colonel Theoneste Bagassora, the Directeur de Cabinet of the Ministry of Defense, with Ngirumpatse's consent, and that on 12 April 1994, Bagassora arranged for weapons to be issued to persons manning roadblocks. Thousands of civilians were killed in Kigali by 12 April 1994. According to the trial chamber, these distributions of weapons substantially contributed to the killings at roadblocks in Kigali by this date. Consequently, the trial chamber convicted Ngirumpatse for aiding and abetting genocide, extermination as a crime against humanity, and murder as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2 in relation to the distribution of weapons on 11 April 1994, and for committing these crimes as a member of a joint criminal enterprise based on the distribution of weapons on 12 April 1994. The trial chamber also convicted Caramera as a superior for these crimes pursuant to Article 6.3 of the statute, and took Ngirumpatse's superior responsibility for Bagassora's and the Kigali Interrahme's crimes into consideration as an aggravating circumstance in sentencing. The appeals chamber finds that the indictment failed to put Caramera and Ngirumpatse on notice that Bagassora was alleged to be their subordinate and that they were being charged with superior responsibility for his crimes. Accordingly, the appeals chamber reverses the finding that Caramera and Ngirumpatse are responsible under Article 6.3 of the statute for failing to prevent or punish Bagassora's criminal acts. Additionally, the appeals chamber considers Judges Pokar and Ramarason dissenting that the trial chamber erred in finding that the only reasonable inference to be drawn from the circumstantial evidence was that Ngirumpatse consented on 11 April 1994 to the distribution of weapons to the Interrahme at roadblocks. Accordingly, the appeals chamber finds Judges Pokar and Ramarason dissenting that the trial chamber erred in concluding that Ngirumpatse aided and abetted the killings based on the distribution of weapons on 11 April 1994. Moreover, the appeals chamber observes that Ngirumpatse's purported agreement to the distribution of these weapons manifested his agreement to participate in the joint criminal enterprise and represented one of his significant contributions to it. In view of the trial chamber's error in finding that Ngirumpatse consented to the distribution of weapons, the appeals chamber, Judges Pokar and Ramarason dissenting, considers that the trial chamber erred in finding that Ngirumpatse participated in a joint criminal enterprise as of 11 April 1994, and therefore erred in holding him responsible for the killings that resulted from the distribution of weapons by members of the joint criminal enterprise on 12 April 1994. However, in view of the trial chamber's findings that Ngirumpatse was also liable as a superior of the Kigali Interrahme pursuant to Article 6.3 of the statute for the killings perpetrated in Kigali by 12 April 1994, the Appeals Chamber finds him criminally responsible for these crimes and affirms his convictions on this basis. Similarly, Caramera remains convicted as a superior of the Kigali Interahme pursuant to Article 6.3 of the statute for these killings. G. Killings following President Theodore Sindukwabo's speech at Sylvain Nzabonimana's installation ceremony. The trial chamber convicted Caramera and Nzabonimana for committing genocide through their participation in a joint criminal enterprise, the common purpose of which was the destruction of the Tutsi population in Rwanda in relation to the killings that followed President Theodore Sindukwabo's speech at Sylvain Nzabonimana's installation ceremony as the new prefect of Butare Prefecture on 19 April 1994, following the removal of the former prefect Jean-Baptiste Habyalimana. The trial chamber further convicted Caramera and Nzabonimana based on these events for extermination as a crime against humanity and murder as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2. Caramera and Nzabonimana challenged these convictions. The Appeals Chamber, Judge Tushmekhamedov dissenting, is not convinced that Caramera and Nzabonimana demonstrated any error in the trial chamber's findings related to their responsibility for the killings which followed the speech given by Sindukwabo's at the installation ceremony of Nzabonimana on 19 April 1994 that would result in a miscarriage of justice. H. Meeting at Murambi Training School. The trial chamber found that on 18 April 1994, during a meeting at the Murambi Training School in Gitarama Prefecture, Caramera, Nzabonimana, and other authorities intimidated local officials, warned them to support the interim government's policy, and told them not to interfere with the Interahme. The trial chamber also found that following the meeting, area burgmasters stopped trying to protect Tutsis and allowed the Interahme to massacre them. The trial chamber relied on these findings in concluding that Caramera and Nzabonimana eliminated the resistance offered by the immediate superiors of the perpetrators and thereby substantially contributed to the killing of Tutsis in Gitarama Prefecture. The trial chamber convicted Caramera and Nzabonimana of genocide, extermination as a crime against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions and of Additional Protocol 2, for aiding and abetting and committing, through their participation in a joint criminal enterprise, the killing of Tutsi civilians in Gitarama Prefecture, which followed their participation in the meeting. Caramera and Nzabonimana challenged their convictions based on their roles in the Murambi Training School meeting on 18 April 1994. The Appeals Chamber considers that Caramera and Nzabonimana have not demonstrated that the trial chamber erred in assessing the evidence in relation to the meeting at the Murambi Training School. However, the appeal chamber notes that the trial chamber's conclusion that Caramera and Nigarampatse aided and abetted the killing of Tutsis in Gitarama are based on the same facts as its conclusion regarding Caramera's and Nigarampatse's liability pursuant to a joint criminal enterprise. In the circumstances of this case, the appeals chamber proprio motu finds that Caramera's and Nigarampatse's responsibility for participating in a joint criminal enterprise fully encompasses their criminal conduct and thus does not warrant a conviction on the basis of aiding and abetting the same crimes. Accordingly, the appeals chamber reverses their convictions on the basis of aiding and abetting. Meetings in Kibuye. The trial chamber convicted Caramera and Nigarampatse of direct and public incitement to commit genocide pursuant to Article 6.1 of the statute in relation to speeches delivered by Caramera and other authorities at a meeting held at the Kibuye Prefecture office on 3 May 1994 and by President Theodore Sindikubwabo at a meeting held in Kibuye on 16 May 1994. The appeals chamber finds that Caramera and Nigarampatse have not demonstrated any error in the trial chamber's assessment of the elements of direct and public incitement to commit genocide in relation to the 3 May 1994 meeting and the 16 May 1994 meeting. J. Civil defense. The trial chamber found that the interim government issued 5 documents related to civil defense between late April and mid-June 1994, which set in motion an agreement to mobilize extremist militiamen and armed civilians to attack, kill, and destroy the Tutsi population of Rwanda. The trial chamber considered it undisputed that the documents were agreed upon by the interim government and derived at least in part from recommendations by Caramera, Nigarampatse, and the MRND. In addition, the trial chamber found that on or about 25 April 1994, Felician Kabuga organized a meeting to create a national defense fund to purchase traditional weapons to massacre Tutsis, and that Caramera and Nigarampatse knew or had reason to know of its creation. The trial chamber convicted Nigarampatse of genocide, extermination as a crime against humanity, and murder as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2 through the basic form of a joint criminal enterprise in relation to the issuance of the civil defense documents and the creation of the fund. The trial chamber found Caramera guilty of aiding and abetting and instigating these crimes based on the issuance of 2 documents that he authored, both of which it found to have had a substantial effect on the commission of the crimes. The trial chamber further found Caramera guilty of these crimes through the basic form of a joint criminal enterprise in relation to the issuance of the other civil defense documents and the creation of the fund. Caramera and Nigarampatse challenged their convictions arising out of the issuance of civil defense documents and the creation of the fund. The appeals chamber finds that Caramera and Nzabonimana have failed to demonstrate that the trial chamber erred in finding that, when placed in their proper context, the civil defense documents encouraged the ongoing killing of Tutsis. The appeals chamber further considers that Caramera and Nzabonimana have failed to demonstrate that no reasonable trier of facts could have concluded, based on the totality of the evidence, that the fund was established for the purpose of rearming assailants with the intent of continuing the massacre against the Tutsi population. The appeals chamber notes, however, that the trial chamber's conclusion that Caramera instigated the continuing killing of Tutsis that resulted from his 25 May 1994 letter and his mid-June 1994 instructions is based on the same facts as its conclusion regarding Caramera's liability pursuant to aiding and abetting. In the circumstances of this case, the appeals chamber proprio motu finds that Caramera's responsibility for instigating fully encompasses his criminal conduct and thus does not warrant a conviction on the basis of aiding and abetting the same crimes. K. Bisesero Hills. The trial chamber found that from 13 May 1994, national and regional authorities from Kibuyo Prefecture ordered and instigated attacks in Bisesero Hills that killed thousands of Tutsi civilians. In addition, around 18 June 1994, according to the trial judgment, Caramera ordered a mopping up operation against Tutsis in Bisesero, resulting in the deaths of scores of Tutsi civilians. The trial chamber viewed Caramera's order as a substantial contribution to the common purpose of the joint criminal enterprise, namely the destruction of the Tutsi population in Rwanda. The trial chamber convicted Caramera and Nzabonimana for committing genocide, extermination as a crime against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions, and of Additional Protocol 2 through the basic form of a joint criminal enterprise in relation to these killings. The trial chamber also found Caramera responsible as a superior for the attacks and killings committed in Bisesero on or after 25 May 1994 by civilian participants in the civil defense program, by local authorities who were part of the territorial administration, and the Gisenei Interachme. This was taken into account as an aggravating circumstance in sentencing. The appeals chamber finds that Caramera and Nzabonimana have failed to demonstrate any error on the part of the trial chamber in finding them responsible for the attacks in Bisesero Hills on or about 13 May 1994 and on 18 June 1994. L. Rape and sexual assault. Caramera and Nigirampace submit that the trial chamber erred in convicting them of genocide and rape as a crime against humanity under the extended form of joint criminal enterprise for the rape and sexual assaults of Tutsi women committed in Ruhengeri Prefecture during early mid-April 1994, in Kigali-Ville Prefecture during April 1994, in Butare Prefecture during mid-late April 1994, in Kibuye Prefecture during May to June 1994, and in Gitarama Prefecture during April and May 1994, and elsewhere throughout Rwanda. They submit that the trial chamber also erred in finding them responsible as superiors for the rapes and sexual assaults committed during the genocide by the Kigali and Gisenyi Interrahme. The appeal chamber finds that Caramera and Nigirampace have failed to demonstrate that the trial chamber erred in its assessment of the legal and factual elements of these crimes. M. Conspiracy to commit genocide. Turning to Caramera's and Nigirampace's challenges to the trial chamber's findings on conspiracy to commit genocide, the appeals chamber concludes that the trial chamber erred in finding Nigirampace guilty pursuant to Article 6.1 of the statute for conspiring with Caramera and others to commit genocide. The appeals chamber is not convinced that the general finding that MRND leaders were linked with the interim government and influenced its decision-making process is sufficient to conclude that Nigirampace, as chairman of the MRND, must have influenced ministers from his party and the interim government in relation to the civil defense program. There is no evidence that Nigirampace might have influenced the instructions issued by Kambanda on 27 April 1994, the documents issued by Kambanda and Caramera on behalf of the interim government on 25 May 1994, or the instructions issued by Caramera in mid-June 1994. Even assuming that Nigirampace wielded authority over ministers from his political party, his mere position of authority cannot suffice to infer, as the only reasonable conclusion, that he influenced the decisions taken by them and in fact agreed or intended to agree to their ultimate decisions. The appeals chamber dismisses Caramera's arguments and upholds the trial chamber's finding that Caramera conspired with others to commit genocide by at least 25 May 1994. And extermination as a crime against humanity and murder as a serious violation of Article 3, common to the Geneva Conventions, and of Additional Protocol 2. The appeals chamber finds that Caramera's and Nigirampace's submissions that the trial chamber erred in entering convictions against them for extermination as a crime against humanity and murder as a serious violation of Article 3, common to the Geneva Conventions, and of Additional Protocol 2, based on the same events and forms of responsibility underpinning their respective convictions for genocide, are without merit and accordingly dismisses their arguments in this regard. O. Cumulative convictions. I will now turn to the prosecution's appeal. The prosecution submits that the trial chamber erred in law by finding that cumulative convictions for conspiracy to commit genocide and genocide are impermissible, and by failing to enter a conviction against Caramera and Nigurampatse for conspiracy to commit genocide. As previously mentioned, the appeals chamber reversed the trial chamber's findings on Nigurampatse's responsibility for conspiracy to commit genocide and upheld the finding that Caramera conspired with others to commit genocide by at least 25 May 1994. The appeals chamber further notes that Caramera was sentenced to life imprisonment and that the prosecution has not sought to reflect in the sentence any possible additional convictions. Accordingly, the appeals chamber dismisses the prosecution's first ground of appeal in relation to Nigurampatse. However, the appeals chamber, Judge Afande dissenting, grants in part the prosecution's first ground of appeal in relation to Caramera and finds that the trial chamber erred in not entering a conviction for conspiracy to commit genocide. However, in the circumstances of this case, the appeals chamber, Judge Ramarason dissenting, does not find it necessary to enter this conviction on appeal. P. Contribution of Caramera's speech at the 3 May 1994 meeting to the Bisesero killings. The prosecution contends that the trial chamber acquitted Caramera of genocide and other crimes relating to killings in Bisesero on or about 13 May 1994 on the basis of his speech at the 3 May 1994 meeting. It submits that the trial chamber erred in failing to find that Caramera's speech substantially contributed to the killings of Tutsis in Bisesero. The appeals chamber finds that Caramera's responsibility for this crime through his participation in a joint criminal enterprise fully encapsulates his criminal conduct and concludes that a finding that he ordered, instigated, or aided and abetted the killings in Bisesero would have no impact on the verdict and accordingly dismisses the prosecution's second ground of appeal. Q. Superior responsibility of Nigurampatse for the Bisesero mopping up operation. The prosecution submits that the trial chamber erred in concluding that Nigurampatse was not liable as a superior in connection with the mopping up operation and further attacks against Tutsis in Bisesero in June 1994 perpetrated inter alia by the Gisene Interrahme. The appeals chamber, Judges Tuzmekhamedov and Afande dissenting, finds that the trial chamber erred in finding that it had an insufficient basis to conclude that Nigurampatse bore responsibility for the crimes of Gisene Interrahme during the mopping up operation, resulting in the death of scores of Tutsi civilians, and reverses this finding. The Appeals Chamber, Judges Tuzmukhamedov and Afande dissenting, considers that the trial chamber made sufficient findings to establish this form of responsibility in its legal findings on superior responsibility. Accordingly, the Appeals Chamber, Judges Tuzmukhamedov and Afande dissenting, finds that Nigarampatse bears superior responsibility for the mopping up operation and the resulting killings. The Appeals Chamber notes that Nigarampatse was already convicted of this incident pursuant to Article 6.1 of the statute, that his responsibility as a superior was generally considered as an aggravating circumstance in sentencing, and that, in any event, the prosecution has not sought an increase in sentence with respect to this additional finding of responsibility. The Appeals Chamber therefore declines to consider any potential impact on sentencing that this new finding of responsibility under Article 6.3 of the statute might have had. Are pre-8 April 1994 allegations and conspiracy to commit genocide. The prosecution submits that the trial chamber erred in finding that the allegations concerning pre-8 April 1994 events did not support the count of conspiracy to commit genocide. The Appeals Chamber finds that the prosecution has failed to demonstrate that the trial chamber committed an error in the assessment of the evidence which would occasion a miscarriage of justice. Accordingly, the prosecution's fourth ground of appeal is dismissed. S. Sentence. Turning to the sentence, the Appeals Chamber finds that Caramera and Nigarampatse have not demonstrated any error in the trial chamber assessment of their sentences. As previously mentioned, the Appeals Chamber has reversed several aspects of trial chamber's findings with respect to the criminal responsibility of Caramera and Nigarampatse. Nonetheless, they remain convicted of very serious crimes. The impact, if any, will be mentioned during the reading of the disposition. I would now like to ask Mr. Caramera and Mr. Nigarampatse to stand while I read the full text of the Appeals Chamber disposition in this case. For the foregoing reasons, the Appeals Chamber, pursuant to Article 24 of the statute and Rule 118 of the rules, noting the written submission of the parties and their oral arguments presented at the appeal hearing on 10 and 11 February 2014, sitting in open session, grants Caramera's 31st ground of appeal in part and Nigarampatse's 44th ground of appeal in part, and reverses the trial chamber's finding that Caramera and Nigarampatse bear superior responsibility over the Kigali and or Gisenei Interrahme in relation to killings following the Murambi Training School meeting on 18 April 1994 and the rapes and sexual assaults of Tutsi women committed outside Kigali from April to June 1994. Grants Judges Pokar and Ramarasol Son dissenting, Nigirompatse's 42nd and 47th ground of appeal in part sets aside the finding that he is responsible pursuant to Article 6.1 of the statute as an aider and abettor and a member of a joint criminal enterprise based on the distributions of weapons in Kigali on 11 and 12 April 1994 and affirms Nigirompatse's convictions for genocide, extermination as a crime against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions, and of Additional Protocol 2, pursuant to Article 6.3 of the statute for the killings committed by the Kigali Interarmée in Kigali by 12 April 1994. Grants, in part, Karamera's 12th and 13th grounds of appeal and Nigirompatse's 47th ground of appeal in part, and reverses the finding that Karamera and Nigirompatse are responsible pursuant to Article 6.3 of the statute for the distribution of weapons by Bagasora. Grants Nigirompatse's 28th ground of appeal in part, as well as his 45th ground of appeal in part, and reverses the trial chamber's finding that he could be held responsible under count 1 of the indictment for conspiracy to commit genocide. Reverses proprio motu Karamera's and Nigirompatse's convictions on the basis of aiding and abetting in relation to the events at the Murambi Training School as the convictions on the basis of joint criminal enterprise fully encapsulate their responsibility. Reverses proprio motu Karamera's convictions on the basis of aiding and abetting in relation to the issuance of the 25 May 1994 letter and the mid-June 1994 instructions as the convictions on the basis of instigating fully encapsulate his responsibility. Dismisses Judge Tuzmekhamedov dissenting in part Karamera's and Nigirompatse's appeals in all other respects. Grants, in part, the prosecution's first ground of appeal and finds that the trial chamber erred in not entering a conviction against Karamera under count 1 of the indictment for conspiracy to commit genocide. Grants Judges Tuzmekhamedov and Afande dissenting the prosecution's third ground of appeal and finds that Nigirompatse bears superior responsibility for the mopping up operation and the resulting killings in Bisesero Hills, dismisses the prosecution's appeal in all other respects, affirms Karamera's sentence of life imprisonment imposed by the trial chamber, subject to credit being given under Rules 101C and 107 of the rules for the period he has already spent in detention since his arrest on 5 June 1998, affirms Judges Tuzmekhamedov and Afande dissenting Nigirompatse's sentence of life imprisonment imposed by the trial chamber, subject to credit being given under Rules 101C and 107 of the rules for the period he has already spent in detention since his arrest on 5 June 1998. Rules that this judgment shall be enforced immediately pursuant to Rule 119 of the rules. Orders that in accordance with Rule 103C and Rule 107 of the rules, Caramera and Nigurampatse are to remain in the custody of the tribunal pending the finalization of arrangements for their transfer to the state or states where their sentences will be served. You may be seated. The registrar will now provide the parties with a copy of the written judgment. This concludes the appellate proceedings in this case. The appeals chamber will now rise.
All rise.
Please be seated. Good morning, everybody. Registrar, would you please call the case?
The Appeals Chamber of the International Criminal Tribunal for Rwanda, composed of Judge Theodore Meron presiding, Judge William Sekule, Judge Mehmet Güne, Judge Liu Dakun, and Judge Arlet Ramarosan, is now sitting in open session today, Monday, 29 September 2014, for the delivery of the appeals judgment in the case of Ildélphonse Nizeyimana versus the prosecutor, case number ICTR-00-55C-A.
Thank you, Registrar. Mr. Nizeyimana, can you follow the proceedings in a language you understand?
Oui, je vous écoute, Monsieur le Président.
Yes, I can hear you, Mr. President.
Let me now ask for the appearances of the parties. First, counsel for Mr. Nizeyimana.
Good day, Your Lordships, and I'm here on behalf of Mr. Nizeyimana, John Philpott, Melissa Canis, co-counsel, Miriam Bouazdi, assistant. Thank you.
Thank you. For the prosecution.
Good morning, Mr. President, and Your Honors. With me, Prosecutor Deborah Wilkinson, Chief of Appeals, Tembile Segote, Samuel Algozin, Appeals Counsel, and William Mubiru, Ndei Marika, Louisa Songwe, Assistant Appeals Counsel.
Thank you, Prosecutor Jallo.
Thank you, Mr. President.
The Appeals Chamber is sitting today in accordance with Rule 118 of the Tribunal's Rules of Procedure and Evidence in the case of Ildélphonse Nizeyimana against the prosecutor. Both Nizeyimana and the prosecutor have appealed against the trial judgment rendered in this case by Trial Chamber 3 of the Tribunal on 19 June 2012 and issued in writing on 22 June 2012. In accordance with the scheduling order of 21 August 2014, the Appeals Chamber will now deliver its judgment in this case. Following the practice of the Tribunal, I will summarize the findings of the Appeals Chamber. Not every issue discussed in the judgment will be addressed in this summary, which focuses on central issues. It is emphasized that this oral summary does not constitute any part of the authoritative judgment of the Appeals Chamber, which will be distributed to the parties in writing at the close of this hearing. Nizeyimana held the rank of captain at the military training school in Butare town called the École des Sous-Officiers, or the ESO. He served as the training school's S2 officer, charged with military intelligence, and as the S3 officer, responsible for training and operations. Nizeyimana was arrested in Uganda and transferred to the Tribunal's detention facility in Arusha, Tanzania, in October 2009. Nizeyimana was charged with genocide, crimes against humanity, and serious violations of Article 3, common to the Geneva Conventions, and of Additional Protocol 2, in connection with attacks, killings, and rapes that took place in Butare Prefecture between April and July 1994. The trial chamber convicted Nizeyimana of genocide, extermination and murder as crimes against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions, and of Additional Protocol 2. Nizeyimana was sentenced to a single term of life imprisonment. Alibi challenges. Among the challenges in his appeal, Nizeyimana submits that the trial chamber erred in assessing his alibi for 21 and 22 April 1994. The trial chamber convicted Nizeyimana for attacks committed on or around these 2 days that resulted in the killings of Pierre Claver Karenzi, Remy Rwekaza, and members of the Mutabaro and the Riankwaya families, as well as the serious bodily and mental harm caused to prosecution witness ZAV. In assessing Nizeyimana's alibi that he was engaged in a reconnaissance mission outside of Butare town during these 2 days, the trial chamber discussed 1. The evolutions in Nizeyimana's notice of appeal, concerning which ESO soldiers accompanied Nizeyimana on this mission. 2. The demeanor of the alibi witnesses. 3. The credibility of individual alibi witnesses and the consistencies and inconsistencies in and between their evidence. And 4. The evidence of Nizeyimana's participation in the crimes for which he was ultimately convicted on those days. Based on these considerations, the trial chamber found that the evidence supporting his alibi lacked credibility or was insufficiently probative to raise the reasonable possibility of its truthfulness. The appeal chamber finds that the trial chamber acted within its discretion in taking these considerations into account and in concluding, based on its overall careful assessment of the evidence, that the alibi evidence was ultimately not credible. The appeal chamber finds no merit in Nizeyimana's contentions that the trial chamber shifted the burden of proof and impermissibly considered the alibi evidence in isolation instead of cumulatively. In this regard, the appeal chamber agrees with the trial chamber's observation that, and I quote, the mere presentation of alibi evidence does not necessarily raise the reasonable possibility that it is true and that it is within the discretion of the trial chamber to assess it, unquote. Nizeyimana has not demonstrated that the trial chamber erred in exercising this discretion. His arguments are therefore dismissed. The appeal chamber will now turn to the crimes for which Nizeyimana was convicted. Killing of members of the Ruhitaniana family. The trial chamber determined that around 17 April 1994, armed civilians detained members of the Ruhitaniana family at a roadblock at the Akanyaru border crossing. ESO soldiers freed this family and brought them to the ESO camp. The following day, according to the trial chamber, Nizeyimana ordered that the family members be returned to the roadblock where they were killed. The trial chamber concluded that Nizeyimana ordered their removal, knowing that it would lead to their death, and that he was aware of and shared the principal perpetrator's genocidal intent. The appeals chamber finds that Nizeyimana has failed to demonstrate that the trial chamber erred in assessing the credibility of prosecution witnesses and in rejecting defense evidence as unbelievable. Likewise, Nizeyimana has not demonstrated any error by the trial chamber in reaching its conclusion, as the only reasonable inference available from the circumstantial evidence on record that he had the requisite mens rea. The appeals chamber accordingly dismisses Nizeyimana's appeal in relation to this killing. Killings at Kiahinda parish. The trial chamber also found that around 18 April 1994, an attack was launched against the primarily Tutsi civilians who had sought refuge at Kiahinda parish. Thousands were killed. According to the trial chamber, the only reasonable conclusion that could be inferred from the circumstantial evidence on the record was that Nizeyimana contributed to the planning of the attack and authorized the participation of ESO soldiers in it. The trial chamber relied on evidence that, 1. Nizeyimana visited the parish the previous day. 2. He served as the officer in charge of intelligence, training and operations at the ESO, which was the operational command center for Butare and Gigonkoro prefectures. And 3. Around 11 ESO soldiers, led by ESO's chief warrant officer, Paul Kanyashamba, participated in the attack using specialized heavy weapons which could weaken the structural safe havens of those sheltering inside the parish. Although Nizeyimana alleges that the trial chamber erred in its assessment of the evidence in relation to the killings at Kiahinda parish, the appeals chamber finds that he has failed to demonstrate any such error. Concerning whether Nizeyimana's involvement in the attack was the only reasonable inference that could be drawn from the record, the appeals chamber finds Judge Gunay and Judge Ramarason dissenting that the trial chamber erred in inferring that Nizeyimana visited the parish prior to the attack in order to inspect the facilities for the purpose of planning the attack. Without further evidence of Nizeyimana's individual actions or intentions during this visit, no reasonable trier of fact could have eliminated the alternative reasonable inference that Nizeyimana's presence at the Kiahinda parish was to participate in a delegation to evaluate the security situation and assist with easing tensions between those seeking refuge and the gendarmes. Moreover, the mere fact that Nizeyimana had experience within the S2 and S3 offices and that the ESO was the operational command center for Butare and Gigonkoro prefectures do not compel as the only reasonable inference that Nizeyimana was involved in the planning and authorization of the attack on Kiahinda parish. His position at the ESO did not indicate that he was the only officer who could have authorized the attack, and the trial chamber did not examine the possibility that Lieutenant Colonel Tarkis Muvunui could have authorized the attack. It should have done so, particularly in light of defense evidence that Kanyashayamba reported directly to Mouvenet. For these reasons, the Appeals Chamber, Judge Gounet and Judge Ramarasson dissenting, reverses Nizeyimana's convictions for genocide, extermination as a crime against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions, and of Additional Protocol 2 in relation to the killings committed at Siahinda Parish. Killing of Rosalie Gikanda, the former Queen of Rwanda, and others taken from her home. Nizeyimana also challenges the trial chamber's determination that he was responsible for the killing of Rosalie Gikanda, the former Queen of Rwanda and the Tutsi, and others taken from her home by a group of SO soldiers on or around 20 April 1994. The trial chamber relied primarily on two prosecution witnesses to find that Second Lieutenant Jean-Pierre Bizimana reported Gikanda's murder to Nizeyimana and concluded that the only reasonable inference was that Nizeyimana authorized her killing. The Appeals Chamber dismisses Nizeyimana's contention that the trial chamber erred in its assessment of the evidence. In addition, the Appeals Chamber finds that he has failed to demonstrate that there was another reasonable inference available from the evidence which favored him. The finding of his culpability for these killings remains undisturbed. Killing of Remy Rwekaza and attack on prosecution witness ZAV. The trial chamber also held Nizeyimana responsible for ordering the killing of Remy Rwekaza and prosecution witness ZAV at a roadblock on or about 21 April 1994. Rwekaza was killed and witness ZAV suffered serious bodily and mental harm. Nizeyimana submits that the trial chamber improperly prevented the defense from fully cross-examining witness ZAV and consequently that it erred in relying on his testimony. These submissions are lacking in merit. They are dismissed. Killing of Pierre Claver Karenzi. Nizeyimana further challenges his conviction for the killing of Pierre Claver Karenzi at the Hotel Fosson roadblock around 21 April 1994. The trial chamber observed that there was no direct evidence demonstrating that Nizeyimana ordered or authorized this killing. It concluded, however, that the only reasonable inference was that the instructions Nizeyimana issued to SO soldiers to kill Tutsis at another barrier earlier in the day were necessarily transmitted to this roadblock, and that this significantly and substantially contributed to Karenzi's killing. There is no evidence, direct or circumstantial, of such a transmission from one roadblock to another. While the trial chamber was entitled to rely on circumstantial evidence, the mere facts that the two roadblocks were located close to one another and a similar pattern of killings was occurring at those roadblocks are insufficient to establish as the only reasonable inference that Nizeyimana's orders to kill two Tutsis at one roadblock were necessarily transmitted to the other roadblock. The appeal chamber finds that other reasonable inferences can be drawn from the evidence and accordingly finds that the trial chamber erred in holding Nizeyimana responsible for this killing. As a result, the appeal chamber reverses Nizeyimana's convictions for genocide, murder as a crime against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions, and of Additional Protocol 2 in relation to the killing of Karenzi. Killing of Jean-Baptiste Matabaro, Zéphanie Niarnkwaya, and others. The trial chamber found that around 22 April 1994, Nizeyimana, accompanied by a number of ESO soldiers who forcibly removed members of Deputy Prosecutor Jean-Baptiste Matabaro's family and persons staying at his home, as well as civilians who fled to and were staying at the nearby home of Sub-Prefect Zéphanie Niarnkwaya. The soldiers separated the male heads of households, including Matabaro and Niarnkwaya, from the group and shot them to death. The soldiers subsequently opened fire on the others in the group, killing a number of them. The trial chamber convicted Nizeyimana for these killings based on his presence and instructions during this incident. In reaching these conclusions, the trial chamber relied on the evidence of 3 prosecution witnesses who were among those taken from the Matabaro compound during this incident. Nizeyimana submits that the trial chamber erred when it denied his motion to recall these witnesses on the basis that their immigration documents were disclosed after the close of proceedings. The appeals chamber finds that in denying this motion, the trial chamber's analysis and ultimate conclusion are consistent with the exercise of its discretionary power. Nizeyimana also alleges that the trial chamber unreasonably excused major inconsistencies in the testimonies of prosecution witnesses and erroneously favored prosecution evidence over defense evidence in assessing issues of credibility. The appeals chamber is satisfied that the trial chamber reasonably evaluated the evidence and Nizeyimana has not demonstrated any shifting of the burden of proof. Accordingly, the appeals chamber dismisses these submissions as unfounded. Killing of Beata Wambaya. The trial chamber further found that Nizeyimana was liable for ordering the killing of Beata Wambaya at a roadblock on or about 5 May 1994. On appeal, he has challenged the trial chamber's evaluation of the evidence and its decision to rely solely on the testimony of a single prosecution witness. The appeals chamber finds that Nizeyimana has not demonstrated that the trial chamber erred in assessing the evidence or in exercising its discretion to rely on the uncorroborated evidence of a witness whom it found to be credible. This aspect of his appeal is dismissed. Joint criminal enterprise and superior responsibility. With respect to the modes of responsibility, the trial chamber found Nizeyimana responsible through the basic form of joint criminal enterprise liability in relation to all of the above-mentioned crimes except for those arising out of the attacks on Rwekaza, witness ZAV, and Wambaya. He challenges the pleading of the joint criminal enterprise, as well as the conclusion that he was a participant in it. The appeals chamber is not convinced that Nizeyimana has identified any error in the pleading of joint criminal enterprise in the indictment or in the trial chamber's consideration of this issue. The appeals chamber further notes that the trial chamber provided a detailed reasoned opinion with regard to the joint criminal enterprise and finds that Nizeyimana has not established any error in its analysis concerning his mens rea and participation therein. His contentions are dismissed. The trial chamber also found that Nizeyimana could bear superior responsibility for these crimes, except those related to the attack on Siakinda Parish and Karenzi, and indicated that to take this into account in sentencing. Nizeyimana argues that he did not exercise effective control over the perpetrators and that the trial chamber erred in concluding otherwise. The appeals chamber finds no error in the trial chamber's analysis or in its conclusion that Nizeyimana exercised effective control over the perpetrators and had the material ability to prevent or punish crimes in each instance. His argument to the contrary is dismissed. Prosecution appeal. Turning now to the prosecution's appeal, the prosecution submits that the trial chamber erred in failing to convict Nizeyimana as a superior for killings committed by SO subordinates at Butare Hospital from April through June 1994. The trial chamber found that, in general, the perpetrators of killings at Butare Hospital were not sufficiently identified as SO soldiers, and therefore that Nizeyimana's effective control over the perpetrators had not been proven. With regard to two killings, the trial chamber found that they were committed by SO Corporal Fulgence Niyibizi, but that it had not been established that Nizeyimana had the requisite knowledge of these crimes to incur superior responsibility. The appeal chamber finds that the prosecution has not demonstrated any error on the part of the trial chamber and dismisses this aspect of its appeal. The prosecution likewise appeals Nizeyimana's acquittal for rapes that were committed at Butare Hospital and submits that the trial chamber erred in failing to convict Nizeyimana as a superior for the sexual violence committed by his SO subordinates. The trial chamber concluded that Tutsi women were raped at the hospital on numerous occasions between April and June 1994. Relying on a number of factors, however, the trial chamber found that the evidence was ambiguous regarding the identity of the perpetrators and that, as a consequence, Nizeyimana could not be held responsible as a superior for these crimes. Among the factors relied upon by the trial chamber was that, in one instance, the age of the soldier who raped a prosecution witness was incompatible with the relative youth of SO soldiers. Based on the record in this case, the appeals chamber finds that age alone was an insufficient basis for excluding the possibility that the soldier was from the SO, and that the trial chamber erred in determining otherwise. Even taking this error into account, the appeals chamber is not convinced, in light of the other factors considered by the trial chamber and the totality of the evidence, that the only reasonable inference would have been that the perpetrators of the rapes were SO soldiers. The prosecution has not met its burden on appeal to show that all reasonable doubt of Nizeyimana's guilt has been eliminated. The appeals chamber therefore dismisses this ground of appeal. The prosecution further submits that Nizeyimana should have been convicted as a superior for the killings of Tutsi civilians at Butare University around 21 April 1994. The trial chamber found that members of the Presidential Guard and SO soldiers entered Butare University, separated Tutsi students from other students, and killed them away from the campus. According to the trial chamber, the evidence could be interpreted to reasonably reflect that the SO soldiers were resubordinated within the command structure of the Presidential Guard, and that it had therefore not been proven that Nizeyimana exercised effective control over the SO soldiers who contributed to the killings. The prosecution merely asserts that Nizeyimana had effective control over these SO soldiers and refers to factors which the trial chamber itself considered in finding that Nizeyimana had effective control over SO soldiers only in some instances. The prosecution fails to point to any error in the trial chamber's analysis and findings. Its challenge is dismissed. Sentencing. With regard to Nizeyimana's appeal of his sentence, the appeals chamber finds that he has failed to demonstrate that the trial chamber imposed a manifestly excessive sentence or erred in its consideration of mitigating factors. As previously mentioned, the appeals chamber, Judge Guney and Judge Ramarason dissenting, has reversed Nizeyimana's convictions for the killings of thousands of displaced persons at Siahinda Parish. The appeals chamber has also reversed his convictions for the killing of Karenzi. Nonetheless, Nizeyimana remains convicted of very serious crimes. The impact of the appeals chamber findings on Nizeyimana's sentence, if any, will be noted in the disposition. I would now like to ask Mr. Nizeyimana to stand while I read the full text of the appeals chamber disposition in this case. For the foregoing reasons, the appeals chamber, pursuant to Article 24 of the statute and Rule 118 of the rules, noting the written submissions of the parties and their oral arguments presented at the appeal hearing on 28 April 2014, sitting in open session, grants Judge Guney and Judge Ramarason dissenting Nizeyimana's 10th ground of appeal and reverses Nizeyimana's convictions for genocide, extermination as a crime against humanity, and murder as a serious violation of Article 3, common to the Geneva Conventions, and of Additional Protocol 2, in relation to the killings at Siahinda Parish around 18 April 1994. Grants Nizeyimana's 26th ground of appeal and reverses Nizeyimana's convictions for genocide and murder as a crime against humanity and as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2 in relation to the killing of Pierre Claver Carenzi at the Hotel Faucon roadblock around 21 April 1994. Dismisses Nizeyimana's appeal in all other respects. Affirms Nizeyimana's convictions for genocide and murder as a crime against humanity and as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2 for the killing of the Ruhitaniana family around 18 April 1994. Genocide and murder as a crime against humanity and as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2 for the killing of the former Queen of Rwanda, Rosalie Gikanda, and the others taken from her home on or around 20 April 1994. Genocide for the killing of Remy Rubakaza and serious bodily and mental harm caused to witness ZAV at the Gikonkoro Siangugu and Kigali Road Junction roadblock on or about 21 April 1994, and murder as a crime against humanity and as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2 for the killing of Remy Rubakaza. Genocide and murder as a crime against humanity and as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2 for the killing of Beata Uambaya at the Gikonkoro Siangugu and Kigali Road Junction roadblock on or about 5 May 1994, and murder as a crime against humanity and as a serious violation of Article 3 common to the Geneva Conventions and of Additional Protocol 2 for the killing of persons taken from the Matabaro and near Ankwaya households around 22 April 1994. Dismisses the prosecution's appeal in all respects, sets aside the sentence of life imprisonment imposed on Nizeyimana by the trial chamber and imposes a sentence of 35 years of imprisonment, subject to credit, being given under Rules 101C and 107 of the rules for the period he already spent in detention since his arrest on 5 October 2009. Rules that this judgment shall be enforced immediately pursuant to Rule 119 of the rules, and orders that in accordance with Rules 103B and 107 of the rules, Nizeyimana is to remain in the custody of the tribunal pending his transfer to the state where his sentence will be served. Mr. Nizeyimana, you may be seated. Asseyez-vous, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. President.
to deliver the copies of the written judgment to the parties? This concludes the appellate proceedings in this case. The appeals chamber will now rise.
All rise.